So our next presentation is going to be talking about bought or sold. What happens with a merger or an acquisition? It looks as though we're looking for Susan. Are you ready to begin your presentation?
I'm ready.
All right, go ahead and get your slides started, and we'll introduce you. There you go.
Is that good? Are we good now? Okay.
Yep, looks good.
Thank you. Thank you. Sorry about that. Okay, I'm Susan Poliquin. I'm the Director of Document Services at Definiti, and we work very closely with your retirement plan consultant to make sure that all of your document needs are met. Before I get into the specific topic that we're going to cover today, I do want to introduce, as Elke said, our special addition to the Definiti team, and that is our in-house ERISA counsel, Karen Toth. Karen, do you want to say hello?
Yes. Hi there, everybody. I'm Karen Toth. Let's see. I am unmuted, so folks can hear me. I am a little bit new to Definiti. I've been here for about a month and a half now, but I am not at all new to retirement plans. I've been an ERISA lawyer for, I'm dating myself, but more than 20 years now. And I have worked at law firms, and I've also worked at a record keeper. So I always like to say that when I help my clients, I bring the full perspective, lots of different perspectives of 401k plan administration. I've helped employers, I've worked at the record keepers, and I've worked at consultants, and I've worked at TPAs. So I bring, just a great sort of full perspective to my ERISA work here. The only other thing I'll say is I generally work behind the scenes, so you won't see me a lot. What I really do is support your RPC sometimes when you have some very sort of technical and precise questions. Although there may be a time when you'll speak with me directly. So if that happens, I'm really looking forward to working with everybody, and I'm glad to be here.
Thanks, Karen. Perfectly said. Karen, as well as the document team, are all kind of in the background, but we wanted to be able to share with you that there are all of these professionals in the background to help your retirement plan consultant. Your retirement plan consultant is your main go-to person, but he or she has access to all of us every day. And we are always acting in the best interest of you, the client, to make sure that you get your needs met and your questions answered. So with that said, I'm going to go ahead and dive into our topic for today, which is bought or sold. And what this has to do with, we've seen a real uptick over the last couple of years of mergers and acquisitions. That just seems to be the way of the world right now. So if you find yourself in that position as either the buyer or the seller, or are anticipating something like that down the road, we wanted to go over some of the things that you might want to consider as you're doing this type of planning. We're going to cover some of the different transactions that are typical in these mergers and acquisitions. We'll talk about some service crediting rules. We'll go over some examples and then just summarize in some key takeaways. So the type of transactions we typically see, the first two are the most common. There's an asset sale and then there's a stock sale. So with an asset sale, that's when the seller is selling off some of its stuff. Okay, they're not selling the entire company, they're not selling the name of the company or the entity itself. They're simply selling some of their assets. It could be a book of business, it could be a specific location, a division. There's some portion of their company that they're selling the assets for. The seller then maintains the current ownership of the actual company. They're just letting go of the stuff. Typically with this stuff goes some of the employees as well. And we'll talk about how that impacts the plan in just a couple of minutes. The second type of common transaction that we see is a stock sale. So this is when this selling company sells its outstanding shares to the buyer. So the entire company is being sold. Here, the ownership transfers from the seller to the buyer in full. And then the third one, which is less common, but we do see it, so we want to let you know about it and let you know that we can certainly assist you if this comes up, is in the event of a merger, when two companies, two separate legal entities combine to form one new legal entity. And so that new legal entity then owns everything of those two companies that came together. And so we can assist you in how it affects your retirement plan when you're doing that. What we see happen sometimes is when companies are engaged in these types of transactions, there's lots of moving parts. They're trying to figure out logistics and employees and assets and machinery and all different types of things. But what we really want to make sure that we emphasize is don't forget about your benefit plans, specifically your retirement plan. Unfortunately, we've seen in the past, which is why we wanted to put this as a topic, is that buyers or sellers tell us about these things after it's happened. And when that happens, your options are limited, and some of the ramifications could be not as positive as you'd want it to be. So engaging us in the conversation with regards to how it's going to affect the retirement plan early on will help us to help you through that process. Timing is everything. So your go-to person, as we keep on telling you, is your retirement plan consultant. Our retirement plan consultants know when they hear the word merger, acquisition, stock sale, asset sale, any of those, they will contact the document and legal team to get full guidance. There will be information we'll need to get from you to get the specifics of what the transaction is, when it's expected to happen, what plans might be involved. So there'll be a little bit of fact finding that we'll want to get, but then we will come up with a plan that will make you comfortable that you've hit all the points and you won't have any surprises after the transaction closes. That's our goal. So in an asset sale, the employees of the seller that end up moving to the buyer are considered terminated employees. The plan participants would then be eligible for a distribution from the retirement plan of the company that sold them. Okay, so it is considered a distributable event, and they would be paid out just like any other terminated employee. The employees would then have the option to take that money and roll it into the new plan if the new plan allowed it, or if the company that they're going to has a plan, or they could roll it into an IRA or simply keep the money. The seller's employees would then be new hires of the buyer. So they would leave the company that sold in the asset sale, terminated employees, and with the new company that they're now working for, they would be considered new hires as of the date of the transaction. And then they would become eligible for the buyer's plan according to whatever their normal eligibility requirements are. What we see often is in a situation like that, the buyer will say, you know what, for employee morale and other reasons, we want these new employees to be able to participate sooner than they might otherwise as a brand new employee. We can help you with that. We can amend your plan to allow for a special entry date. We can amend the plan to recognize service with the prior company. But again, we would want to have that conversation as early in the process as possible so that there wouldn't be any interruption of that participation if that's the goal. In a stock sale, the employees are treated as employees with continued service. Because the buyer is buying the entire company, including all its assets and its liabilities and its benefit plans, it's considered just continued service from the seller to the buyer. So what happens to the retirement plan is really up to the buyer in this case. And this is probably the most critical in a stock sale. The timing is crucial. And the reason why is if the buyer already has a plan and they don't really want to have to deal with the seller's plan at all, the seller's plan must be terminated prior to the close of the transaction. If you wait until after the transaction happens, you, the buyer, own that plan, and now it's your headache, okay? That doesn't mean that you're stuck or that you can't do something, but if the intent is we don't want to have to deal with that plan at all, those decisions should be made prior to the close of the sale. Again, that is why it is really critical to bring us in as soon as administratively feasible so that we can help you and give you all the options based on what your goals are. So that's one of the options, is terminating that seller's plan. You can also merge the seller's plan into your plan if that's the case. So if it does go past and you say, nope, we'll just merge the two together, that's an option. There's some intricacies to that because you have to look at provisions of both plans. You have to look at whether there's protected benefits. Under ERISA, there are certain benefits that you can't reduce. And so if you're merging plans together, you have to, identify those and then make sure that the resulting plan accounts for those. And again, we can help you with that. We are very, very experienced at comparing those documents, identifying those protected benefits, and coming up, and laying out your options of what you need to do to make that decision. Or we've seen in some cases where they'll keep both plans separate. And so it'll be, one company that has two separate plans, and they'll each have each company maintain their own plan. Sometimes it's temporary. Sometimes there's reasons why they want to keep it separate. So we can help with that as well. Again, there are certain provisions in the plan document that should be in place to avoid testing issues. And we can do that analysis and look at those things ahead of time so that you don't run into any surprises at year end or in the event of an audit or something like that. So definitely, if you're engaging, thinking about in the process of, reach out to your retirement plan consultant and let us help you. And then the third option, as I mentioned, it's not as common, but under the merger, the surviving company becomes responsible for all the plans that are sponsored by the two legal entities that combined. And if they both have plans, then similar to a stock sale, they would need to ensure that both of those plans are then merged into the one company plan. We would do the same thing we would do under a stock sale, in that we would look at both plans, identify those protected provisions, come up with, a plan for you to going forward, making sure that you're not violating any of those protected benefit rules. So let's look at a couple of examples. So in this first example of an asset sale, a simple asset sale, we've got Salt and Spice Company. They have several divisions. One of their divisions, the sugar division, is no longer part of their core business. So they decide to sell the division to Sweets Galore. And the transaction date is 9/30. Now we're going to pretend we're like in August, so we know about this in advance, right? Salt and Spice maintains the current ownership of all other divisions of the company. So they're not giving up the entire company. They're just selling off the assets of one division. The sugar division employees would then be considered terminated from Salt and Spice, and then they would be treated as new hires of Sweets Galore on the transaction date. So some of the considerations for Salt and Spice, the one who sold off that division, because the sugar division employees are now terminated, again, it's a distributable event, so they're eligible to take a distribution from the Salt and Spice 401k plan. The one thing that, again, we would want to have you be mindful of, and we can help you in the event that this is a large division, is the division big enough to constitute a partial plan termination? A partial plan termination is typically more than 20% of the work of plan participants leaving. And if that's the case, then it triggers other things like vesting. And so we would want to take a look at that to see if that sale triggered any of that, to make sure that, again, you stay in compliance and that you don't run it afoul of the Department of Labor or the IRS down the road. For Suites Galore, they've simply hired a group of new employees. And again, they can amend their plan to credit the employees for their service with Salt and Spice if they choose to. They're not required to, but oftentimes companies will do that just so that the employees stay whole. And if they don't decide to do that, they can certainly be subject to whatever the current eligibility requirements are of their plan. So that's an asset sale. Let's look at an example of a stock sale. So here we have Burt Inc. and Ernie Inc. Burt Inc. buys 100% of the stock of Ernie Inc. on October 1st, 2022. Each of them have 401k plans. They each have different entry dates. So what happens if the plans are not modified in any way? We would have to review the plan provisions of each. It could be the case that all employees are eligible for both plans, which is not typically what we want. We would take a look at the plan documents to see if there is language that allows for a transition period for these types of transactions. Ideally, that's what you want. The IRS has this transition period to allow for time to determine what is the best route for these plans. And so we would want to review the documents in advance to make sure it has that language so that you don't have to make decisions immediately. Depending on the timing of the transaction, you don't want to have to be making rush decisions that could have longer term effects. So having this transition period in your document affords you a longer period of time to do proper planning. So again, under this stock purchase, Burt Inc.'s 401k plan excludes acquired employees during the transition period, which is what we would hope to see in your plan document. And if that's the case, that transition period runs from the date of the acquisition until the last day of the plan year following the transaction. So in this case, it starts on October 1st, which is the date of the acquisition, and it's going to run until the following December 31st, so 12/31/2023. So that gives them about 14 months to come up with a plan, to go forward, to give it their full attention and make sure that those protected benefits and so forth are looked at and preserved properly. So it's allowing them, the other big thing here is coverage testing. So it allows them to operate the plan going forward without worrying about coverage testing. So if the plan is excluding automatically any employees that are acquired during the transition period, typically you can exclude groups of employees. That's not a problem as long as you pass coverage. In passing coverage, there's a threshold of 70% of the non-hires. If for some reason, if this was a large enough division that it could cause that coverage testing to fail, that could become costly and just a real headache. And so this transition period allows not only the extra time to plan, but it allows automatic coverage testing passing. So you don't have to worry about failing that coverage test. So we would really want to make sure that that was in place, again, prior to the transaction. It's not something we would be able to do after, if that provision wasn't in there. You can't put it in after the transaction. It has to be in place prior to. So just can't stress enough, bring us in as soon as you're considering these things to just see what all the pieces that need to be addressed are. So the key takeaways here are: make sure the plan provisions are known before the transaction. Reach out to your retirement plan consultants. They are your number one go-to. And they don't necessarily have all the answers, but they have the access to the resources that will get the answers for you. The document planning is key. We really want to make sure that all of these things are addressed sooner rather than later. If the timing works out that we're not brought in as early as we can, doesn't mean that we can't help you. It's just that there are more options for you, better planning the sooner we're brought in. Be sure to communicate to all parties. Again, there's so much going on during a merger and acquisition that We just don't want the retirement plan to get lost in the shuffle of all of the other things that you are certainly going to have to deal with merging companies. Then let your retirement plan consultant be your consultant. We are there to support her. I have a team of 6 document specialists and myself, plus Karen. We're there to support our RPCs. We all have years and years and years of experience. Personally, for these mergers and acquisitions, I've probably done a couple hundred of them over the last few years. So we're all very familiar with these. And we want to be able to help you with this. We want to make sure that you're happy and that you're feeling confident that you're doing things in compliance and that your plans are not going to give you surprises under an audit or under, at year end or something like that. All right.
Yeah, great. Thank you so much, Susan. And special thanks to Karen. Thanks, Karen, for being here today. As she mentioned, she is a resource for us. So if you find that you need that resource, know that she is available and she is in-house. So she's available to our team whenever we need her, which I guess is a good thing for her. I don't know, for her, it's a lot, right? But we're glad that she's here. So I wanted to kind of talk about some of the available resources. Obviously, the session is available as a recording, so you'll have that. And then we also produced an article some time ago about mergers and acquisitions specifically. That's available on our website. So we'll list that additional resource for you so that you have access to it when you see the video. Susan, I do have a couple of questions. Are you for it?
Absolutely.
All right, awesome. So what happens if someone has bought another company 3 years ago and just kept the plan separate? What do they do now?
Yeah, I mean, the first thing is reach out to your retirement plan consultant. So that's always number one. If it's already happened, and that quite honestly is very common. We don't find out a lot of times through the collection of annual census, because one of the questions on the annual questionnaire is, what other companies do you own? So sometimes we find out about it that way. And so I know I kept stressing, bring us in early, but your options are not eliminated if you don't. It's just that you have more options. So definitely bring us in. We'll do the analysis. We'll take a look at both plans and we'll tell you what your options are. Have a conversation about, what do you want to do? Do you want to keep them separate? Continuing on? But the first real step is contact your retirement plan consultant. Let them know that you have more than one plan going on because of a merger or an acquisition. And let's take a look at your specific situation and come up with a plan based on what your goals are.
Yeah, no question. Yeah, if we've said it once, we've said it a lot. Your retirement plan consultant is there for those kinds of questions. And the earlier that you bring them in, the more we can help you. So I'm going to just echo that there, Susan. Let's see. If I buy another company, do I have to move the assets from that plan into my plan?
Again, whenever anyone says they're going to buy a company, the first thing we're going to ask is it an asset sale or a stock sale? Because it does make a difference. So if the intent is to take over that plan, which you can do under an asset or a stock sale, then again, what's your goal? Are you going to keep them separate, or is your intent to merge the plans and only have to deal with one plan? Typically, if you're merging the plan and you only want one plan that you have to be responsible for, typically the assets are all, at the same place. You want to be mindful that the options that you provide to your participants are consistent. So if you're offering certain assets, investment options to some participants, you want to make sure that the others have the same options. That's part of the non-discrimination. So that would come into play, if you're having it merged, but having assets in different places. So that would be one of the things that we'd want to take a look at and see whether or not that presents any kind of issues. Yeah,
I'm also wondering if how how the disposition of the retirement plan should be handled, would you recommend that be part of the purchase agreement? Maybe that should be.
It should always be discussed as part of the negotiation. It should be addressed because there's certain things that are defaulted. If it's not addressed, like for instance, in an asset sale, unless it's specifically negotiated that the buyer will assume responsibility for that plan, if they don't have any rights to that plan once the transaction closes, unless they have negotiated that and have put in writing that, yes, we're going to be, assume responsibility for that plan. They certainly can do that. It's not common, but they can. And likewise, if it's a stock sale, if their intent is, we don't want to have to deal with that buyer's plan because we don't know how they've operated it. We don't want anything to come out of the woodworks, right? It could be tainted with, some bad behavior. Then oftentimes they'll say, we don't want to have to deal with that, terminate it. Well, if it's not negotiated and it's not been terminated, at least on paper, prior to the close of the transaction, then the buyer owns that plan, lock, stock, and barrel, and all hidden secrets. They own it, and they then have to deal with anything that might come as a result of that. So that's the critical. That's why, I know I sound like a broken record, but that's why I stress that knowing early on is really key to knowing your full options. That's when you can really consider those things.
Well, yeah, just having the options is a benefit, and just knowing that we're here to help walk you through that. Hopefully that answers some questions that others had for today. Sure. It looks as though that is the last question that we have on this particular topic. So Susan, thank you so much for your time and your efforts to explain this, and look forward to having you again at future runs. So thanks so much for your time.
Absolutely. Thank you.
Thanks. So a quick reminder that this will be recorded and posted online. So if you wanted to watch it again, you will be able to. And just kind of wanted to touch back on a few things that we will be talking about tomorrow, because believe it or not, tomorrow is the last day of the Definiti Retirement Academy class of 2022. It's hard to imagine. We've put a lot of energy and planning on this particular semester, and we hope that you've learned a lot from it. So tomorrow we have our last 401k 101 class, all about what happens if and when you fail a test. You failed a test, now what? The important thing is, don't panic, we're here to help. And then also, instead of how your plan grows with you, we're going to cover what Definiti creates for you. We're going to show you some of the things that we've talked about this week, some of the resources and materials, and where you can find them. And then our last session is going to be a study hall where you'll have a chance to get to meet all of the different administrator managers on the DC admin and DB admin team. And I'll have a chance to stump them with questions that you may have submitted this rest of this week, questions that they encounter a lot. So it's a good opportunity. If you've got a question that hasn't been answered in this previous week, come to that session and you can ask it there as well. So it should be a great day to wrap up what we're learning here this week and give you a chance to take everything that you've learned and take it into your role and into the next things that you're doing with your retirement plan. With that, I would say class dismissed, and we will see you all tomorrow. Thank you so much for your time today, and we'll see you tomorrow, 1 o'clock Eastern. Thanks, everybody.